Maryland parents are taking their fight over elementary school story time all the way to the Supreme Court, raising concerns about books read to students focused on LGBTQ themes, saying they violate their religious beliefs. On Tuesday, the justices will take up one big question: are public schools violating parents' religious rights by teaching young kids about gender and sexuality without notice or chance to opt out? In Montgomery County, teachers are required to read storybooks that celebrate gender transitions, pride parades, and same-sex relationships. The school board says it's meant to encourage more inclusive thinking. Books like Born Ready, the true story of a boy named Penelope, are part of the reading rotation for teachers. The story suggests that doctors only guess a baby's gender at birth and that children can decide their gender for themselves. In 2023, the Montgomery County School Board reversed its policy requiring parent notification about its inclusivity program, including LGBTQ story times. Before that, students in kindergarten through 5th grade could opt out, but that option was taken away. Court documents express Montgomery Public Schools' reasoning behind the reversal. The growing number of opt-out requests gave rise to 3 related concerns: high student absenteeism, the infeasibility of administering opt-outs across classrooms and schools, and the risk of exposing students who believe the storybooks represent them and their families to social stigma and isolation. But even some principals push back, calling the books age inappropriate, saying they presented gender ideology as fact, dismissed religious beliefs, and shamed students who disagreed. The lawsuit doesn't try to block the curriculum. It argues that forcing kids to participate goes against their families' faiths and violates their constitutional rights. A lower court dismissed the case, ruling that because no one was forced to change their beliefs, there was no violation. The parents who come from Christian, Muslim, and Jewish backgrounds say this isn't about politics. It's about religious freedom and being left out of a conversation they believe matters to their children's values. This case draws parallels to a landmark Supreme Court decision, Wisconsin versus Yoder. In 1972, Amish families fought to pull their kids out of school after 8th grade, despite a state law requiring attendance until age 16. The Supreme Court sided with the families, ruling that their religious freedom outweighed the state's education requirement. For Straight Arrow News, I'm Kaylee Carey. For more unbiased, fact-based news, download the Straight Arrow News mobile app or head to san.com.